Good morning. The Committee on General Government Operations and Federal Foreign and Regional Affairs now convenes this hearing. For the record, today is Tuesday, April 4th, 2017. The time is now 10:30 a.m. In accordance with the Open Government Law, public notices for today's proceedings were provided to senators, stakeholders, and our local media. A 5-day notice was provided on Tuesday, March 28, 2017, and a 48-hour notice was provided on Friday, March 31st, 2017, and both notices were published in newspapers of general circulation. The committee will hear and accept testimony, both oral and written, on the following item: Bill number 38-34 LS, introduced by myself, Senator Michael F. Q. Nicolas, an act to amend subsection 6229.2 and 6229.3 of Article 2 and 6301 of Article 3, each of Chapter 6, Title 4, Guam Code Annotated, relative to requiring that all salary and or class specification appeals be administratively adjudicated before a 3-year review of salary and or class specification for nurses and other public employees be conducted. We don't have any individuals who have signed up to testify, but I will provide a brief overview of the intent of Bill 38-34. Ilisatur and Guam finds, following the implementation of the Competitive Wage Act of 2014, hundreds of employees have filed grievances addressed to specific issues with its implementation. Many of these appeals of the Department of Administration have not been administratively adjudicated. Ilisatur and Guam finds that Imagalahan Guam has publicly discussed conducting a new compensation study, even though many government employees remain in limbo with respect to their grievances and how the previous study was implemented. Ilisatura further finds that failing to bring a final resolution to these grievances could leave those employees behind, potentially widening the disparities caused by an improperly implemented compensation study. Ilisatura further finds that until these grievances are resolved, their costs to Guam taxpayers remain unknown, as would their impact on the affordability of the implementation of the next compensation study. Ilisatura further finds that conducting a compensation, classification, and benefit study before addressing the flaws of the existing compensation plan could end up compounding the problems relating to employee classification and compensation. In a nutshell, before we do a new study, we need to resolve the outstanding appeals of the old study. And right now, that's not written into public law. And so the intent of Bill 38-34 is to make sure that prior to initiating any new compensation studies, the appeals are fully adjudicated with respect to the current study. And that's just to make sure that we're not layering problems on top of each other. So we don't have any individuals who signed up to testify. We have no written testimony that's been submitted. This will go ahead and exhaust the mandates in order to have a public hearing, and we will go ahead and consider Bill number 38-34 as having fulfilled the requirements of being heard. That is all that we have on the agenda for today's hearing. We will go ahead and adjourn this hearing at 10:33 a.m. Sijos Masi.